You're listening to Heavily Accented Philosophy of Law, a podcast powered by the HAPL Project. Okay, welcome to a new episode of the Heavily Accented Philosophy of Law podcast. Nice to see you all back. Nice to see you, Jules. We're recording another episode live. Very nice to have our today's guest Fabrizio Esposito with us. Online, unfortunately, we decided already in previous podcasts that we are never going to have three persons in the same room at the same time.
It seems to be impossible, but we are going to make it at some point.
At some point, probably, yes. Welcome, Fabrizio. Hope that you're relaxed and ready.
I am very relaxed and ready.
Yeah, great. We have this usual manner in the podcast to start with a very typical question, unsurprising question. Jules?
Okay, so can you tell us a little about your academic path to the present in the sense of where did you study, what did you study, something for the audience to know you a little more before we delve into the main topic of the episode?
Right, so I graduated from Bocconi, and it all started there because there was this course that was divided between two groups. Right, so there was the comparative lawyers that were teaching law and economics, and the philosophers of law that were teaching legal argumentation. And there were frictions between what they were teaching. So I got interested into that, and eventually I wrote my master thesis on the topic, and then I started the PhD at the University of Milan, where they were not particularly convinced that it was a philosophy of law topic. So I turned it into a EU law topic at the European University Institute. And then eventually it became the foundation of a career in private law, but in Portugal, after some time in Israel and some time in Belgium. So there are a lot of borders that have been crossed and a lot of accents that have been picked up along the way.
It's always great to have these not so long stories, but extremely complicated.
Yes, exactly. It's like, let's have a sum up of an incredible, long and complex story, which is fantastic.
Who did you work with in Milan, on Bocconi and on the University of Milan?
So when I was at Bocconi, my supervisor was Damiano Canale, and then I've been working also, and to a very little extent, with Giovanni Tuzè. Actually, their work on inferentialism has been very, very important for my own research and for the things that I think can be really helpful for improving research in law and economics, right? Which we will talk about later. Then, when I was at the UI, I worked with a German private lawyer called Stefan Grunman. Then in Israel with Hanoch Dagan, and that was the moment where everything felt like it was coming together, right? Because there was a private law theorist, there was a very strong department in law and economics as well at the University of Tel Aviv. There was also a lot of frictions between these different groups, and that is perhaps the main thing that I brought, that I have been thinking about. The main takeaway from that place was exactly the existence of those frictions.
Dagan is known as a realist, and Tuzè Canale are most well known for their inferentialism. So yeah, it's quite a slide, I think, from Damiano and Giovanni have this tendency to formalize, to work in logic, and Dagan has this tendency to realistically, very realistically put down things in private law. I don't do private law much, and we were talking about other philosophers of law about this obvious leaning of philosophy of law towards public law, and we just started having these conversations, which is actually fascinating. A couple of episodes ago, we had Giovanni Tuzè, but we were not talking about economics and law and economic analysis of law. We had a conversation about
evidence.
Yeah.
We went in that direction, yes.
Absolutely, which is also a great topic. But we don't promise that we are not going to have another episode with Giovanni covering this same topic from another angle. Basically sending him your episode and then like having Giovanni
saying comment on this.
Comment on this.
I hope if also he disagrees, then I'm toast.
Oh.
Right?
Well,
which is a fantastic introduction to start speaking about substantial.
Yes, but then maybe we can think about a next episode at some point with you and Giovanni. Both of you talking maybe about, I don't know, and then fight.
Yeah, like at one point we are moving towards this idea of having a pit of mud and something like that. And like having philosophers of law fighting in it. But easy baby steps. First we talk.
Fighting in the mud of legal theory, private theory, and then foundation of economic analysis of law.
Yeah, that's a fascinating story. I mean, it is a fascinating story because I truly am. All the persons that you have mentioned, I have at least at one point in my life read a lot of their work, and both Jules and I are pretty much close colleagues with most of them, especially with Damiano and Giovanni. We'll have to get Damiano at one point, I think, in the podcast if we manage. Just calling him
to
out.
kidnap him.
Yeah, but the majority of your work.
If I can give you a suggestion on the mud
absolutely
episode on this particular private law topics, I would invite Dagan, either with his current colleague Melvin Eisenberg, or with the person that held Dagan's chair before Dagan, namely James Gordley, who now is in Toulon.
Oh. I am laughing because it sounds amazing.
Yeah, we're doing it. As soon as we manage to resolve all the audio issues that we've been having in the last two episodes, because we had a lot of audio trouble. And
again, we are so sorry, Fabrizio.
Sorry for the delays. But let us kind of start with the substantial questions of the podcast. So we'll be discussing law and economics today, and I would like to open the conversation just with the general question of whether you could tell us something about the state of the field, or how do we stand? What's the situation now in law and economics? And we all have this at least basic knowledge, at least in philosophy of law. You were mentioning that nobody was convinced that you were doing philosophy of law at the University of Milan. But at least from our basic knowledge, we are all acquainted with some of the basic positions in law economics, at least those ones coming from Posner and later on. So in the last 40 years, 45, 50 years, something like that. But it would be great if you could give us kind of an overview of the field.
Right. So this is a field that has been operating, but I would say that in other fields you probably get something similar, with a lot of dualism. So at the beginning there was the Posner versus Calabresi kind of dualism, with Calabresi having a position that was closer to Dworkin's than people from outside maybe realize. And then there was the behavioral turn in economics, right? So you had the Nudge book and all these ideas and libertarian paternalism and all those things. Then Calabresi tried to do a comeback, and this is where I got really inspired when in 2016 he published a book called The Future of Law in Economics, where he made this distinction between economic analysis of law and law and economics that I think for people in the analytical training is very neat, because it says economic analysis of law is the use of an economic theory, it doesn't matter what it is, to tell to the law how the law should be. So the direction of adaptation is unilateral. Law in economics has a more of an hermeneutical approach, where the legal and economic perspectives speak to each other, and then they try to have a fit. And Giovanni presented it as a reflexive equilibrium in some work of his, and Calabresi agreed, at least conversationally, that this was an account he was comfortable with. But guess what? Despite the stronger philosophical credentials of the Calabresian approach, basically no one gave a damn in the field. And, you know, when you start realizing that after you finish your PhD and you enter into the job market, this starts to give you the chill, right?
Gasp.
So what I did, but the question is not about what I did, is the direction that the field is taking. So the direction that the field is taking is that essentially for things that have to do with the information in news, the news markets in the US, a leftist critical approach managed to get a big grant at Yale, and they came up with a movement that is called the Law in Political Economy. There is a collective that is a federation of different associations. So actually, it's quite interesting to look at the evolution of these, not only as a matter of concept and claims, but also the institutional dimension is quite interesting. What I found particularly disappointing was this survival of this process of polarization, right? Because you had this economic analysis of law idea that, if Calabresi's account is fair, and I think it's fair enough, it tends to be unilateral. And then instead of developing this more hermeneutical and interactive relationship between the fields, you have exactly the same thing, but from the left, proposing in the most radical claims that are presented in the manifesto of this movement to do law and political economy without economics, which, as you can realize from the outside, is rather weird. And one of the weirdest thing about this name game is that at the University of Chicago, that is normally associated with the other group, Milton Friedman, who is very clearly associated with the other group, held the chair of political economy. So there is a clear attempt to take labels that supposedly should identify a field at a non-political level, right? So you should be able to do political economy if you are from the left, the radical left, the right, the radical right, somewhere, everywhere in between. You should still be able to recognize yourself with the field of political economy. But clearly there is an attempt to claim these labels for political purposes, which I and other people find very disappointing. But then it is clearly the case that for the dynamics of academia, what I am observing is that the people that try to operate in the reasonable in between, let's call it, struggle to get outlets that publish them, And so what do you do if after 2 years of law student edited journals you get rejected with your papers in a very competitive academic environment like the US, for example? You start doing something else. Either because you do not survive in academia, or because in order to survive in academia, you decide that you reorient your research. So then what survives mainly are the more clearly organized groups. I am quite curious, to be honest, to see what's gonna happen now, especially in the US with the election of Trump, because this more leftist group was very excited during the during the Biden administration, because the chairs of the different authorities, starting with Lina Khan of the Federal Trade Commission, were very sympathetic to their positions. But now that the reality is a completely different one institutionally, I am optimistic, but I am very optimistic by nature that maybe there will be more of a willingness to work for the compromise. The question is whether on the other side now there will be any interest to do that. So this is the situation we're in, and in Europe, essentially people are mirroring a similar divisions.
Mm-hmm. It's a very interesting, I don't know, overview, I think, from, in my case, a field that I don't know much about. I was wondering, and also it's very interesting because it lets us see this relationship between institutional issues, political issues, and naturally the pursuit of knowledge, because sometimes we tend to think about, for example, legal philosophy or legal theory as things that happen in a vacuum, and this is not the case. And maybe things that are dealing with some kind of economics, or at least with the label of economics, they make us think that they tend to have, I don't know, more influence in practice or more influence from the practice. But what I have a follow-up in regards to this situation, because you said so that we have economical analysis of law on the one hand, that we have this law and political economy movement on the other hand, and then this limping third way that is trying to come by, or that you have. But I was wondering, what is this law and political economy about if they are not using anything coming from economics?
So I think that claim is really an exaggeration.
Okay.
And what I think that they are trying to do is to look at heterodox approaches in economics, or like it is. I guess it is something similar to virtue signaling. So they really want to signal that they are not like Posner 1980.
Okay.
But to be to me, this is a serious concern, because as Bojan was mentioned before, we are the kind of law and economics that we incorporate in our foundational training in legal philosophy is very far from providing an account of the current state of the art in its best light.
Mm-hmm.
Now the problem is, and I think, and to me this is one of the challenges for the future that the field has, is that the idea that law and economics is an interdisciplinary or transdisciplinary field is largely an overstatement, in the sense that you have law people interested into economics and economics people interested in law, but the capacity of combining methods, research questions, and so on is very limited. And I think that because of the general climate, we do not really we do not really see attempts to understand what would be the best light for the other half of the room, so that you advance for what are your condition of promotions in your own department, which is completely understandable, right? If you do law and economics, but you are in economics department, then you will be evaluated, considered for tenure track, promoted, and so on, according to economics conditions of success. If you are applying for jobs in a law department, it's going to be the other way around. So this is a challenge that remains foundational, I think, for this field. But in order to improve the quality of the research, I think that a little bit of empathy is necessary. To give you an example, it is not uncommon to go at conferences and hear economists present basically in law and economics. There is a lot of interest in choices between basic legal solutions like negligence versus strict liability. And this is a bit bizarre, because if you look at a piece of legislation that is normally taken as a strict liability based, like product liability in the European Union, there are so many exceptions, and it is so nuanced that the attempt to say, oh, for the problem of product liability, we should have one or the other, doesn't really capture what is going on. So that's why I think that sometimes the reading the piece of legislation that supposedly you are modeling should perhaps be a starting point for economic analysis. And I wonder to what extent, this is a question that I have for you guys, would you say that perhaps this is a fair criticism also for legal theorists and philosophers? So the disconnect from the actual practice that you are theorizing about. Maybe, to be fair, maybe this is a problem of theorizing in general.
We have been focusing for quite some time, even in the podcast. I think we documented it quite well, and have been thinking intensively about this amount of interrelationship between legal practice and philosophy of law. In fact, so much that we even made an IVR workshop. Jules and I, we made an IVR workshop on this. Now, when you put it like this, theorizing about legal theory and legal practice to continental philosophers, oftentimes it seems like you're basically now, you're putting everything done in philosophy of law under one umbrella term. But I think that is kind of an issue that is related to this question, which field are you coming from? For example, in the United States, oftentimes you have philosophers doing or discussing legal issues, which is kind of miles far from lawyers discussing philosophical issues regarding the law. And now I just received an invitation for a seminar or something in which one theorist is presenting something, and I read, like, until we started talking, I read the first 2 pages, and I was thinking at that exact same moment that this is completely unintelligible from the perspective of anybody who had only contact with law, which doesn't have to be by itself a kind of this hyper problematic thing, but you're addressing a question that's not a question in legal practice in any way whatsoever. You're addressing a question that not even the most educated lawyer can even begin to understand how you're addressing it, and so on and so on. So it's...
What was the question?
Yeah. So let's just say that it's about geometry.
Oh, okay, yes.
Okay, so you maybe, not to leave you out of the loop, but probably Jules received the same
Yes,
invitation.
I know what you're talking about.
Which is kind of a nice metaphor until it isn't a metaphor. Well, so if it's not a metaphor, right, it's just, etica more geometrico demonstrata and quinque pars diviso. So it's basically trying to mathematize something, but it's not even about mathematizing, because there are some very successful attempts at making or formalizing a part of the discipline.
Making law formal.
Yeah, like for example, if you take Alexis, I mean, I kind of, but this is the thing. You start from an actual, it's just about the approach. You don't have to agree with the conclusions, with the discussions, and so on and so on. So you basically do this. We have this modality of reasoning that is called balancing, and we already have it there. Like it was done in Prussia, it was done by German courts, it was done by European courts, it was done by so on, and people are obviously using it. So now let's try to start from there and to kind of formalize this. And you make your attempts to rationalizing and formalizing, and eventually in this interplay of practice and theory, you can argue that the practice became richer, and the practice became more kind of strict, analytical, conscious of what it's doing, and the theory became kind of informed by the practice and by the modalities of reasoning. Jules, you don't agree? I can see by your face.
The thing is, I know what was the reception, for example, in different high courts in Latin America, and I don't agree with. I think that it has been used, for example, in this case, Alexis' formalization of the practice of argumentation in this sense, the balancing. It has been used just as an argument of authority in regards to just one decision, but it has not been used, I think, in the way in which Alexis wanted it to be used, or as such a rationalization device as Alexis thought about it. So I think that there is a risk when we go towards formalization. I really like formalization. My matrix is, I come from a group in which like formalizing and then law and logic was a very big thing.
Yes, you do.
I really like formalization, but I also see the risks, because we tend to go to formalization and then to use that in a very loose way to basically win arguments, in the sense of, oh, look at this formula, oh, look at this number. That's it. That's subjective. It is what it is. And then, naturally, most formalizations in this sense, they don't want that. They, for example, Alexis didn't want that. It was just a device to control, for example, argumentation. But it's not being used like that.
Yeah, but that sounds to me... Sorry,
Fabrizio. But imagine a constitutional court where the abstract weight of a principle has been considered free on the scale for 20 years. Like, and now we decide that the freedom of self-determination of the pregnant woman is not that important. Right? So if it is explicit that it was 2 to the power of 3 for 30 years, or that the right to life of the fetus was 2 to the power of 2 instead, right? Or 2 to the power of 0 even, then it becomes the argumentative burden for the court. I think it becomes almost unsurmountable, I would say. A word chosen to emphasize the heavy accent part of this podcast. because either everybody was wrong, or you need to claim that from the last decision on this matter, there has been such a fundamental shift in societal values, if you admit that that is constitutionally relevant. So it provides some it doesn't, I don't think that it justifies, it helps justify in the first decisions of the line. The first decision of the line is going to be more or less free, but it creates an incremental amount of constraints over time, because even if it is not this particular right, then you can start making systematic comparison with other rights that have been provided certain values, and these should inform the way of arguing. I think an interesting research question for that area, which is not my area, so it's easy for me to suggest this, is to actually ask whether over time this is the type of arguments, systematic arguments, that the parties have started to develop in order to justify their to make their cases in this kind of argumentation. But one thing that is quite interesting for today's topic about Alexei is that once you formalize, so first, one of the researches that I did that I enjoyed, that actually I presented in Geneva, I think Julieta was there, has to do with the use of economic concepts in proportionality analysis by legal theorists. So one thing that Alexei did that was where he was very careful, even when he got it wrong, but what he got wrong was not relevant for his point, was that he used economic concepts in order to elucidate certain features that, as Bojan was saying, the practice in his understanding had. So there was some similarity between the economic concept of the indifference curve and the legal concept of proportionality. Then the problem started in the secondary literature when they start to say, oh, since it is the same thing as this economic concept, then we can ascribe to the legal practice this property that the economic concept has, without searching for that property into legal reasoning. And that is the problem. But one thing that I have been looking at, and at least I teach to the students, but I never wrote about it, is that there is an economic concept that is called social welfare function. And if you structurally look at the social welfare function, it is very similar to the weight formula. The difference being that in the social welfare function, you have an algorithm to aggregate individual utility profiles like mine, Julieta's, and Bojan's. In the weight formula, you aggregate the relative value of rights in certain contexts. But once this similarity is established, then you immediately realize that despite the fact that Alexei presents the weight formula as with that particular structure, there are at least 5 different social welfare functions. And Matthew Adler has a very accessible book with some unnecessary parts on of formalization that Julieta is going to love. And then the question becomes, which social welfare function best describes the practice of this particular court, right? In the choice of the abstract weight and the level of intensity, do we find implicit concepts that make it so that people use constitutional courts normally use a prioritarian social welfare function? Or would if the choice between a utilitarian social welfare function or a prioritarian social welfare function, if made explicit, would it make courts change the way in which they are deciding cases? So I think this is a very nice example of the potential benefit of establishing these connections, because if we accept that there is at least some analytical value in Alexis' work, the next step would be what do we gain if we build on Adler's work, who is just incorporating economist work on social welfare functions in his own way of thinking about public law. And does this provide additional clarity, or does it make explicit areas of discretion that we are actually uncomfortable that constitutional courts actually exercise, and probably maybe they're not even aware that they exercise those. So one of the reasons why I like this, and I love that this came out naturally, this thing about the weight formula and Alexis as a topic, is that if you ask law and economics people, what is where is it that in legal, in law schools, they score more points, it is really not constitutional adjudication. Right? So Posner has this has this chapter from 2018 where he essentially gives the old man version of his own previous work, where he says, for market-related things, we work great. But where we cannot, we just, it's constitution. Constitutional debates are undecisable. And maybe the policy is undecisable with constitution, with economic arguments, although I think that Sunstein would disagree to a significant extent. But it is our understanding of how the reasoning is structured that should be our primary focus of analysis. And that is why I think when they said that maybe my research is not in philosophy of law, it was a bit unfair.
I absolutely always thought it that at least economic analysis of law, or the parts that I know are pertinent to philosophy of law, are in fact you have to have this philosophical grounding, or at least we can put it like this, like Posner always had this philosophical grounding, and in this sense, I never considered it much. Even now in PhD studies, I have an entire part of the literature that they have to read on economic analysis of law. But let me ask you this question, because I want to clarify a couple of points, both with your position in regards of these strains of law and economics and some of the methodological problems. Now, obviously, this economic analysis of law versus law and political economy is grounded in, and the third way that you were mentioning is grounded in these big methodological issues. And I wanted some explanations, if you are willing to provide, of the methodological underpinnings of these positions. In a sense, for example, the part that you cited from Posner was this part that is very humble towards the relation between law and economics. Like now we have kind of like economic evaluations of legal solutions within a certain domain of law, in the sense that in private law it makes a lot of sense for us to consider the economic or economically analyze the consequences of judicial decisions, and to follow that in the analysis of the work of courts and so on and so on. Like a measuring stick. So economy as a measuring stick in legal decision making in the domain of private law. What is your position regarding this methodological stance? And do you think, even if we grant that in constitutional law we can do a similar thing, do you think that that this modest role of economic or economy methods in law is appropriate for this relation between law and economics?
So I think that, if when it comes to, I think that there is something into the idea that when it comes to market relations, economists have more to provide, to bring to the conversation in comparison to situations where we're talking about family relations, right? Because their methodological, their tools are tools that are designed primarily for analyzing those kind of interactions. And even if there are some similarities with other types of interactions, there are also differences. So there is, you need to be more cautious. The problem is I think one big problem is the following. We have two choices. So on the one hand, we can say, okay, so the Economist and these choices have been on the table for a very long time. So the Economist is a social engineer, right? So if we accept the idea of the Economist, if this is what we're talking about, so then we are providing metrics, right? As Bojan was saying, and then the political process and eventually the legal makes decisions. Eventually, these decisions are enshrined into the legal system, and then institutions operate on the basis of these choices. Economists measure the outcomes, and with certain processes, the outcomes are revised. Now, if instead we try to claim that it is natural that the market should optimize certain metrics, we are doing a completely different exercise. Because between this naturality, there is actually a lot of normative choices that are remaining implicit. And this is an area where economists have themselves a lot of problems. Because the training that they have does not provide them with strong philosophical foundations. There is a ton of literature complaining about this kind of problems. So, and then you have the interaction between two mutually reinforcing and individually sufficient forces. On the one hand, you have the professional urgency to justify your profile as particularly relevant, your methodology as reliable. So you end up arguing in favor of metrics that you can measure. And on the other hand, you have the people that support certain metrics because they understand that those metrics will lead to outcomes that they like, for whatever reasons they like them, right? So the combination between these two groups in favor of measurability is really problematic. And then there is also, I think, a very important element of conceptual impoverishment. So if one of the things that you associate to standard law in economics, I think, is the claim that efficiency and distributions are separated. And then if you dig, this lands you into a paper by HAPL and Chauvel talking about this thing. But in their context, distribution means distributive justice, right? So it's not distribution between me and you in the exchange, but it's distribution between you and me as member of the community. The subtitle of the article makes it clear because it talks about the poor, right? So the word poor is in the, but if you were to make a survey among law and economics people, distribution means any distributive problem, right? So even the problem of distribution between parties in an exchange. So the distinction between commutative and distributive justice has disappeared from the discussion. And this creates a linguistic and conceptual barrier, because in order to have a proper conversation, you need to have people that have learned that it is efficiency versus distribution, that one is the domain of the first welfare theorem and the other is the domain of the second welfare theorem. They need to bring it all together and revise the conceptual framework that they use. And I honestly believe that this wouldn't be that difficult to do, but we are not doing it.
Mm-hmm. Going forward with this methodological part of the conversation that we're having, and then something that you have, I think, is identified as a problem in methodology in the way in which we are thinking about the object of the field. What other methodological problems do you see in law and economics?
So I think to me, at least, the biggest problem is, and this is where the work of Damiano and Giovanni really helped me, is this widespread lack of interest for the reasons that are given to justify decisions. It is not always like that. Okay, so even in textbooks, if you look at the Hand formula that provides an economic account of negligence, they look into the court reasoning, right? There is convenient. Then when it comes to provide accounts of other decisions, as soon as looking at the reasoning is not convenient to claim that the analytical tool is doing useful work, the reasoning is disregarded. And I think this cherry picking, where the theory is fixed and the object of analysis changes, needs to be abandoned for the opposite. The object of analysis is fixed, like in proper theorizing and evidence-based research, and what needs to be adapted is the theory. So to the extent that this is not what is happening, and I think in many situations this is indeed what has not been happening for a long time, there is a very fair criticism, and to me this is particularly disappointing because I strongly believe that with all its flaws from a normative point of view, the analytical core of traditional economic theory is really helpful. So for example, in my book, where I criticize extensively this idea of efficiency as total welfare, because I think efficiency as consumer welfare describes better the structure of the legal system in those areas that are most relevant. The analytical prescription that comes out from these many years of work is simply to say, you know what? Instead of looking at institutions in terms of transaction costs, we can use the cousin of transaction costs, which is agency costs, which is a minor change. And we can start making sense of institutions as mechanisms that solve principal agent problems by creating other principal agent relations. And I would expect that public law oriented legal philosophers would feel comfortable with the idea that there are agency relations all over the place into public law, right? But when we move to private law, private lawyers are very reluctant themselves, private law theorists are very reluctant themselves into looking at things in this way, because the analytical framework of agency is normally associated to fiduciary relations, which are different from contractual relations. And people get very nervous when you try to say, oh, but even if institutionally an exchange is different from a fiduciary, to the extent that it is, there is still something that justifies saying that me buying the milk at the grocery is a principal agent relations of some sort. It is different from me going to the doctor, because the kind of trust that I need to put into the doctor, of course, is different. But still, before drinking the milk, my capacity to be sure that it's not poisoned is non-existent. I need to trust a system that is making sure that that's the case on my behalf. In exactly the same way in which I am trusting a system that makes sure that when the doctor tells me that I need to take a certain pill, it is actually the case that I need to take that pill. So there is the lack of concern with reason giving in law and economics is, to me, the biggest concern.
I'll just briefly circle back to the discussion between theory and practice that we were having like 30 minutes ago. Basically, it was kind of my point. It was that weird Hegelian point regarding legal theory, which is hic Rhodus, hic salta. So you do the things that there is an amount of some amount of practical problems. I'm a pragmatist in this regard. Prompt theoretical problems, theoretical discussion. And I think the theory starts really early on, for example, and like when Fabrizio is talking about law, it's the question of what prompts theoretical reasoning about legal reasoning, for example. And it's usually in law, it is prompted by this thing that you're claiming, the inferential relations within judicial arguments that either state a problem as an economical problem or don't state a problem as an economical problem. Otherwise, you always have these kind of, this might be leftist, otherwise you always have this, like the hidden motives, not this thing, like there is something lurking behind judicial argumentation which might not be. So a reasonable starting point is, I think, for example, the actual argumentation of an actual court that takes into account some economic relations, disregards other relations, and so on and so on. So at least that's the way, Fabrizio, I understood your elaboration on this topic. That like the actual inferential relations of arguments in judicial decisions are what prompts us to engage even in economic analysis of law.
I think it is what should prompt us. I think it is what prompted people originally. But then when the machine started working and it started to attract funding and it needed to keep going and it was going in a direction that was politically attractive, so funding were coming, but it was difficult to sustain with evidence, the conditions of success of arguments were diluted so that the machine could carry on. If you look at the first papers of Posner or like killing or wounding in defense of property, there is an attempt to pay attention to the content of the reasoning that then gets lost over time and then when it becomes normative, right? When it becomes normative, of course, it changes because you do not need to describe anymore what is going on. You have used that previous work in order to accredit a certain goal as legally relevant, and then you carry on. You carry it on with arguments that become increasingly more detached from standard legal practice because you are justified to do that. So you are changing the rules of the game because you say, oh, if we agree that this is the goal, then there are certain methods, there are certain form of arguments that are most appropriate to talk about this goal. And we should pay due care to all of that.
Is it hubris?
And the more generations of people come to your classes, then the more sit on the bench and the more and the more it gets reinforced.
Just a clarification question, because when you were saying that for you this disregard of reason giving in your field, in the investigation of your field, I thought that you were talking about the fact that everyone in your field is doing normative theory. But now, when you are saying that, I am feeling that you were saying that the people think that they are doing descriptive theory and they are doing something that is absolutely not the case.
No, so there is one. It is the case that recently law and economics has become more normative. And it is the case that it was not like that. So when Posner came up with the efficiency hypothesis of the common law, he was making a very sophisticated attempt to present as legally relevant certain economic concepts, and the claim was they are legally relevant because, as Bojan was saying before, exactly like Alexi was doing, this is elucidating the practice. So I do not need, according to, if that were to work, I do not need to provide any normative justification because I'm simply elucidating a practice that is accepted as normative. But then it didn't work. And so the normativity came from the social prestige that the economic profession had for itself, right? The idea that in order to have a well-functioning society, we need to have well-functioning markets, because if we have well-functioning markets, everybody has opportunity and everybody has prosperity, and so on and so forth. So, but one thing that is characteristic of law and economics, but not only of law and economics, I think of many approaches that are capable of methodological approaches that remain lively over time, is that they shift, right? Also in legal theory, in certain moments, the descriptive analytical work is more valued than normative work, and so on and so forth, because there is always these kind of interactions. Right now, what I find disappointing about the current state in my discipline is that we have had 60 plus years of work, but the degree of disconnect from the rest of the law school has been increasing rather than being reduced. The difficulty for the outsider to understand what is the state of the art and whether what is the state of the art from an economic point of view should also count as state of the art from a legal point of view is becoming harder and harder. Now, I think a fair counterpoint or terms of comparison would be whether we think that this is a problem that also legal theory and legal philosophy have. Right?
Yeah, absolutely. I was thinking about that the entire time when we were speaking to law and economics and the approaches. I was thinking about slippage points. For example, when a discipline becomes basically what you were talking about, Jules, earlier, scholastic, the disputes about almost nothing, like exclusive and inclusive legal positivism, it atrophied into this hellscape of unintelligibility at one point. Yeah. And it happened, I was thinking...
Hima versus Martimore in one Oxford handbook, for example.
Yeah, I was thinking, like, I should go back and pinpoint who's to fault there, and so we could point the finger at
I don't think that's necessary.
Yeah, it's not necessary. But it always happens, like, who did this? All of a sudden, like, these entire volumes, as you were mentioning, are produced, and just slips. The academy slips into a direction that distances it completely from any even theoretical concern, because the issues are not even not even have the practical concern, but they don't have any theoretical concern anymore, I think.
But I think that it boils down to what we were speaking at the very beginning of this episode, the institutionalization of the pursuit of knowledge.
Yeah, it's sociology.
In the sense, but just in a descriptive level, I am saying that when you are like institutionalizing more and more the pursuit of knowledge and you are professionalizing this type of thing, you tend to fall sometimes in these things. I don't know, maybe endogamic discussions, very abstract discussions. The institution, like the evolution of the way in which we pursue knowledge, it arrives to a point in which if you institutionalize that, or the practice in a certain way, the institutionalization and the practice in itself generates its own problems also to be addressed. For example, the fact that the participants behave or not behave in a certain way, and then you're like getting more and more distance, for example, from the object or the original object of the knowledge that you are trying to pursue, because you are generating also different expectations about, for example, the actions of the participants, and then also new objects of the practice, which are not necessarily the original object of the pursuit of the knowledge, but then there are these other objects that you are now engaged with.
Yeah, no, descriptively, the point is completely fine. It's just that I tend to look at it in terms of what do you kind of teach students methodology-wise, for example, and how do people approach problems. For example, and you have this in all fields. Let's take literature. I mean, you have probably amounts of texts in philology that are produced on criticisms of Shakespeare's work. In this sense, so like basically you build the entire careers on the for example, you might probably find people who made their entire professional careers on criticizing Fish's comments on classic literature, most probably. And then you have this tendency to distance to completely lose sight of some actual object of inquiry, which is kind of an institutional, I think, also problem, but also I think that can hardly be normatively justified. Justified.
Oh no, we are not. We are not going. We were not speaking in a normative level, just at a descriptive level, because I think that's also what Fabrizio was saying at the beginning. In the sense of there is certain conditions, certain material conditions in which you can pursue some knowledge or not. And you were talking about Fabrizio in the sense of that if we're at the intersection, for example, of trying to do law or trying to do economics, and then you couldn't find funding on one field or the other field because you were doing some intersection of the fields and then being evaluated using metrics of one of the fields or the other, naturally this also puts you in certain positions or puts you in certain ways. And then naturally when you are in a field, maybe the way to maintain yourself in the field stops being this pursuit of the knowledge as originally, and it goes in other directions. Sometimes it happens.
Yeah, mounting, growing a beard.
Yeah.
Writing for yourself, waiting 10 years.
Or criticizing the critics of Shakespeare.
But yeah, of course, Fabrizio, so if I can distill our question from this discussion is, please solve this issue for us.
Or at least solve it
in all the fields.
In all the
fields.
Legal research.
Let's say in law and economics general, at least.
Yeah, what would be in your idea the way forward?
So, I think that one very healthy institutional thing that actually a friend of mine told me they do in in sociology at the University of Milan is they have they used to have a statistician professor, professor of statistics, a very difficult word to pronounce, who essentially was hired by their department, and that would be the last author of every paper and would fix the methodological problems of the research. So you do the research design and and at the end this person comes and helps you doing the extra mile when it comes to data analysis, for example. I think that we have lost this idea that legal theory, legal philosophy, law and economics, legal history, they should be integrated into the research on practical problems. Because this is the naive image that I had about myself in the past. So I have the privilege to study a problem that is so much down the line that no one else has the time or the opportunity to focus on, and eventually this will trickle down and helping maybe improving the quality of an argument that will eventually have an impact down the line. Now, the problem now is that I realize that this line that I'm talking about is not a straight line at all. There are so many bridges that are broken, and perhaps the challenge is to build these bridges more effectively. So I was once at a conference where somebody was presenting a paper on the Opheldian framework, and somebody commented, "Oh, but this is important because judges make these kind of mistakes." And the person who was presenting said, "Oh, I never thought that my research could help a judge." I was like, that's a wrong answer, right? You shouldn't be working at a law firm. You shouldn't be working at a law school if this is how you feel about the Opheldian framework. And, I think that this happens a lot.
I'm absolutely down with you on these issues. I have this, I'm overly Hegelian today, but I always have this discussion at least once with first year and always with fourth year students, because in Belgrade we have Introduction to Jurisprudence or Introduction to Law on the first year, right, and Philosophy of Law on the fourth year for those of the students who opt, and we always have these discussions. I grew accustomed by studying philosophy to abstract and concrete. I use them in a Hegelian way, in which the abstract things are things that are disconnected. That's the easiest solution. When you have two things that are kind of, you disconnect them or you analyze them, you break them down too much into distinct spaces, he calls them abstract. When three things are interwoven together, he calls them usually concrete, which is kind of a bottom-up way of looking at it, of completely reversed for the usual mind. But I always liked it. If you cannot connect at any single point the thing that you're theorizing about with or philosophizing about with with the problem that you started from, or with an actual issue that is shared among at least two persons at the moment of the conversation, it strikes me as insanely abstract in the sense that you cannot, these two things cannot kind of grow together. And this is a perfect example. It works for everything almost for me, at least when I think about things, even for the most kind of, you would say, abstract philosophical conversations. Those are those moments, if you cannot make an example for the thing that you're talking about, then are you really talking about something? And this is the point that you're making. You do Hochveldian analysis, in which you're analyzing basically legal positions, and you're claiming that somebody has a right, somebody's free, somebody's he has the duty and so on, and kind of the statement that you were not ever aware that a judge might, that this might be kind of instructive for a judge, is completely also, I have the same reaction as you do. I mean, how is it possible not to connect these two things? It remains kind of very abstract. And whenever I'm in the situation to kind of speak with judges and to make yourself understandable for people who do practice, usually they find actually pretty substantial value from those things, apart from the question whether they will use it actual sociological, basically, and psychological question, whether they will use your argumentation in their decision, whether they will use the weight formula or the efficiency formulas or economic analysis. They kind of, he's kind of right, he's doing this well, he's making oneself understandable from this perspective is, I think, kind of therapeutic for philosophy. At least I think so.
I tend to agree in this, in the sense of, I think, and I am also guilty of that. Sometimes we just tend to be too abstract, in the sense of maybe like thinking about things for the sake of thinking about things, for example, or thinking about things for the sake of getting funding to keep going, in this sense. But right. I was also wondering whether there cannot be a division of labor within our fields, in the sense of that you have, I think, the different levels of in the pursuit of knowledge. You have a very abstract level, a medium level, which is so the abstract, the very concrete, and then a medium level, which is kind of trying to connect the abstract with the concrete. So maybe the problem is that we cannot be, all of us, in the very abstract level, that if we are in a very concrete level, maybe that is not really worthy, in the sense of that we don't problematize everything that we might, that we just keep going with the practice and then we don't go out of the practice. But then I was sometimes wondering whether this division of labor within our fields could function, and the problem is that just we are focusing, or we are all just in one of these levels, and we don't preoccupy ourselves to try, or at least at some point, to be in the other levels. Question mark.
Okay, so there is a question. Yeah, no, look.
Yeah, of course. Like,
I think that is the very big challenge that we have, because suppose that, to stick with the Ofeldian framework, or you write a paper that clarifies an aspect of the Ofeldian framework. Mm-hmm. What are the chances that a judge in California will learn that in the next 5 years? Non-existent. There is no mechanism. We have no mechanism to synthesize the state of the art and preoccupy ourselves with making it available to the lower level. And I see it very clearly in law and economics, because right now we have this idea, right, that we have the Chicago School, right? So there is this beautiful book, it's called The Analytical Failures of Law and Economics. The framework is great, but then you find statements like, law and economics cannot explain the unconscionability doctrine. Well, I would say that there is a paper by Russell Korobkin in 2003 that does a perfect job, and it has hundreds of citations. So if we strawman the object of our critique to this point, and we get published by Cambridge University Press, nevertheless, right, we have a serious problem. If you keep saying conversationally, I am criticizing the Chicago School, at some point I am bound to ask you, are you criticizing Posner's father and Easterbrook, or are you criticizing Posner's son, who wrote a book criticizing how antitrust betrayed workers? Or are you criticizing the same generation, Cass Sunstein, right, who came up with an idea of making regulation acceptable for libertarians? So, I mean, it is we need to demand to pay more attention in our fields. I think we need to pay more attention to what in other fields is done in terms of knowledge synthesis. So systematic literature review and so on. Sometimes it is easy for me to do some speculative work that has to do with the impact on a certain legislation on consumer behavior, because I can cite 4 or 5 systematic literature reviews that suggest that there is a mechanism in human behavior that is strong enough that is probably the case that is going to be relevant also with this new piece of legislation that no one has investigated empirically. But if I were to tell you, now I challenge you to find a systematic literature review on what is the best economic account of a legal norm, or what are the different legal accounts of economic accounts of legal norms, you're not going to find it. But this is not only about law and economics, it is also about legal scholarship in general, right? So in the law school, we are not very good at using these tools. And I do not know how much time we have left, but there is a thing that I actually would like to run with you. So in the last, when I started being interested into systematic literature reviews, then at some point I realized that essentially, and this was very Freudian in a sense, because my father is a doctor, that methodologically, doctors rock and we suck. Why? Because they are the guys who invented systematic literature reviews. They are the guys who invented randomized controlled trials. And they have a third pillar in their academic work, which is called formal consensus mechanism. Have you ever heard about those?
Yep.
Right. So one of those is the Delphi survey. So you send an open question or a semi-structured survey to a bunch of experts. They give responses. You share the responses. You ask people to update their responses. So what would happen if we were to make use this kind of tools in order to get a pulse of where our discipline is? To ask a very uncontroversial question, there are so many EU law scholars that generally believe that the European Union is a neoliberal institution. They generally believe it, and I generally believe that this is false. But there is no space where we actually engage on this matter in a structured way, because the conditions of success in the peer review process does not require any strong claim to comprehensiveness in the positions that you are taking into consideration. Normally, when we review papers, what we are most concerned with is that there is some sort of internal coherence in the argument, and that the different steps of the argument are sufficiently supported. We do not really review the papers for the comprehensiveness of the perspectives that are taken into consideration. I would say. Maybe I'm not doing my job very well. I don't know.
No. I was thinking about that for a long time. In the last couple of years, I published, and I had the pleasure of working collaboratively with quite some colleagues, and I published at least 5, 6, 10 papers that are collaborative works of collaboration. And I was thinking a lot about that because, as it happens, my wife is a dentist, and she does she works on the faculty also of dentistry here in Belgrade. And she has, I mean, you now, just to do some academic complaining, her H index is like 10 times our combined H index, of course. Yeah, because this is the thing, and it's the introduction for agreeing with you completely in this sense. Now, what you get with a systematic review, if you try to do it in, and I think in most of the non-empirical, at least social sciences, you get this derivative, and somebody was put it succinctly, it's more important to say something new than something true recently, and it's this thing, it's this thing where the reviewer too, at least, always tells you, derivative. Kind of, what does it mean? It's already you have in the Bible, there's nothing new under the sun. Like 4,000 years later, you're still not accepting a paper because there isn't anything new in the paper. And it's this thing where they made an entire field out of systematic reviews. And if you write a systematic review, for example, in a domain like part of the economic analysis of law, or you do a systematic review on linguistic arguments in legal interpretation, or you do a systematic review on inferentialism, or on whatever, postmodernism in legal theory, whatever, you have a slim chance of being accepted in philosophy of law journals. And systematic reviews are actually like this nice way of drawing a line and continuing from there. And it's I find it completely like not at least useful from the perspective of not discovering new things that were already written about 20 years ago very well and very very well argued. So I'm in complete agreement that this part of our institution, the institutional reality we inhabit, is pretty bad. At least let's just
I mean, so how often do you listen to critiques of positivism that have to do with a strawman idea of positivism, of critiques of natural law arguments that have to do with strawman versions of natural law? This is what happens all the time when you leave your bubble, right? The outside version of what is going on, all the nuance that is happening in the bubble, is completely lost. So, so in law and economics, it's very interesting. There is a group of people that does comparative law and economics. And comparative law and economics, if you think about it, has a lot of reasons to be expected to be a very successful field, because comparative lawyers are legal scholars with a certain interest for methodological questions, and they have a connection with the practice that may be legal theories and institutional nuance that maybe legal theorists don't have. So there is an advantage in comparative law from this point of view, and they need frameworks for making the comparison, because putting one thing next to another doesn't mean to compare, right? So maybe economics can provide a useful framework and contribute to build the framework for doing this kind of analysis. And so there is a group of comparative law and economics people that has been writing papers that complain about the fact that comparative law doesn't take them seriously. And if you look at the reasons that are being given not to take them seriously, and at the counter arguments that are given, everyone is talking past each other, because at some level everybody is correct, because I can point to a paper against which those or a line of papers against which that critique works. But then you can point to a group of papers where that critique doesn't work. But the problem is, if I were to ask you, spend one afternoon searching comparative law and economics papers that are good from a comparative law point of view, you don't find that kind of indication, right? So, and probably you have similar with minor adaptations. You see these kind of problems in all in all the fields, especially in the interdisciplinary fields. It is difficult for somebody who comes in to understand what is the best research that they should be reading from their own perspective, which is probably going to be different from the perspective of the person who wrote the paper. And so if we don't create, if we don't invest resources and we do not normalize that it is valuable, for example, if I had the power to implement this, I would most definitely, I would definitely impose that the first chapter of every PhD thesis from my university is a systematic literature review. So I need you to justify that you spend the next 3 years of your life thinking about the problem on the basis of the fact that you can convincingly be assured that on that specific issue, either there is nothing or there is nothing conclusive of what you have is conflicting. And to be honest, I think that this would be very valuable for PhD students, because I think we all had a very high degree of anxiety at some point during our PhD, asking ourselves, is what I am looking at meaningful? Does it make sense to be doing this in comparison to be doing something else? And to reconnect with the institutional dimension. This would be valuable, I think, as a method, even in contexts like the Italian academic system, where in order to get the abilitazione, you need to be sure that you have cited everybody, right? The Italian academic system requires you to pay a special kind of attention to your senior peers, okay? Now, if you mastered the technique of systematic literature reviews, which is not rocket science, by the way, it would be way easier for you to navigate through the difficult times of the abilitazione with a plausible belief that you are actually doing it right. So, honestly, there are in my area there are specificities about my area of interest, but I think I'm really hopeful that in the next few years we will see some serious methodological changes that I consider advances. Probably people may disagree, that we import from other disciplines. Because I'm getting tired, because this is more tiresome than you would expect. I do not know if I mentioned this before. So imagine if we were to make a Delphi survey on inclusive versus exclusive legal positivism.
I'm not doing it so that you know, Fabrizio. Yeah, it's a good idea, but just I'm out.
With the survey saying yes, no, what the hell, why?
Yes, no, and why is a good question.
Why? Sorry.
But you see, this is so let's make it less personal for you. Is the European Union a neoliberal institution? Arguments in favor or against? Open question. You collect 100 answers from experts. You turn them into a structured survey. You circulate it again, and then you start writing papers when you say, oh, it is widely believed that the European Union is neoliberal because this and that. Now, if we actually look at this institutional reform in its institutional context, this actually looks like a justified intervention, even if it is widely believed to be neoliberal. Or maybe, we are talking about an institutional framework that regulates prices of medicines, that has granted the Commission the power to decide what is a fair price in a data exchange contract between business parties. So Maybe there is a liberal part. I'm not so sure how neo it is, but maybe I am completely biased and I am missing a whole population of evils that the European Union has directly or indirectly caused to social policy in a number of areas. So, but we will never have that kind of conversation. And that with the normal research methods that we have, it is going to be very difficult for me to find the paper that is actually help me to change my own perspective. And since doctors use these kind of methods to decide very important things like if you have these symptoms, it is probably the case that you have this disease, or if your disease has reached this stage, this is the best therapeutical protocol for you to follow. Maybe we can try to explore these things to reflect on what is the best notion of efficiency that private law scholars should use in their work. I don't know. At the beginning of the year, after the holidays, I am always very optimistic, and then maybe if we talk again at the end of the next semester, then it will only be about case notes and things like that. I don't know.
I get you completely. Like you, at least you for speaking for myself, you did a great job translating your optimism to me, and I truly think I'm even thinking in this direction. Maybe at times it's not even this huge methodological issue in the sense of this discipline that researches are ways of approaching reality and problems, but a methodics issue. It's just kind of like using these tools that you find in some disciplines in order to bring some structure within the discipline that you're doing. And this structure might be something that is badly needed within the discipline, at least in some fields. So I find myself rather in significant agreement with this kind of, let's try to at least change a bit the approach in order so that we can orient ourselves within the discipline. And I'm not sure that we are doing such a good job. In Serbia, like in Italy, until 15, 20 years ago, we had this as an obligatory part of magisterial works, which were these huge works, basically the same as doctoral works later on.
Right.
And you were supposed to pay special attention toward your peers, and a huge part of this was idolatry. A part of this was idolatry, but when we swung the pendulum on the other side, it went way on the other side. So nobody's under the obligation of do any kind of systematic review, or you just pick an author and stuff like that. The entire forest would be saved if people just read Kelsen. For example, like just kind of, I never do it in conferences, but you know this situation when like my older professors were always doing it, and I kind of understand them to a degree. When somebody gives a paper and you just say, kind of, did you read Kelsen by any chance? Because you're in complete agreement with the stuff that he wrote like 70 years ago about this issue in the XYZ. Yeah. And kind of it's this, also it's a bit, gentlemanly, I think, to just do this research.
But now I think that we are moving towards another issue maybe within our fields, which is how certain circles of the field only read certain literature.
Right.
And I think that this is not something that can be, in any case, fixed, for example, by a methodology, as you were suggesting, because I think that there are some other things in play. As I see it, I am not saying, I am not trying to justify it. I think that from a descriptive perspective, I think that naturally we can go towards trying to use these other tools that Fabrizio was suggesting, for example. to try to build some, I don't know, also more, how do you say this?
Comprehensive,
wider knowledge about what has been researched on, what has been said, what is the actual or current, for example, understanding on a specific topic. But then I think that there are some other things in play that are not just because we are in fact non-systematic in this sense. I think that maybe some things that can be read as we don't want to be systematic in this way.
You're realistic today, Jules. You're just a bit this happy-go-lucky.
We started talking about institutions, and I think that we kept about.
But look. So I think so. The concept here is the problem is the problem of epistemic justice. So you can't really expect people in Oxford or at Yale or in any leading institution in a field to be the ones that are going to lead the crusade for epistemic justice in any field, because they have human nature and self-interest imply that they are the gatekeepers, and therefore you need to somehow force their hand by showing what is it that they're doing wrong, by only talking to each other, citing each other, inviting at each other conferences, doing edited volumes. What is it that is being lost in that debate because the circle is so narrow? Because at the worst case scenario, so if the best claim that they have, ideally would be, everybody, we're doing the same thing as everybody else, but at least in a very complicated world, we provide, our institutional affiliation provides a signal so that if people read us rather than anybody else, they are rest assured that they read high quality stuff that give a proper account of what is being debated. The problem is that in many circumstances, the distance between the center of the nodes of the debate and the periphery of the debate in terms of quality is not necessarily in favor of the center. But if you accept this kind of approaches to literature synthesis, you will never know. So I think this is the problem that we have.
One can try, I think, as a note to Jules' comment, which I think it's one can try at least in the following sense. When you have this little methodology, so let's just make a counterfactual and kind of, if we had this systematic review thing, for example, and you completely disregard an entire field of study that was already presented within a systematic review when you, for example, do economic analysis of law, or you do hermeneutics or legal interpretation or whatever, or authority or something like that. It's usually in many fields, as it should be in philosophy of law, it is considered as a mistake. The least that you can say, it's an omission. It's an important omission. So you have, for example, now, and it's a crucial example, we were talking with my colleague, Miodrag Jovanovic, who wrote a book on philosophy of international law. Now, it won't come as a surprise to Fabrizio, to Jules, and to myself that one of the important figures in that book is, and I mentioned him already, Hans Kelsen. One would say that Hans Kelsen is the most important philosophy of law figure when you talk about international law, because the guy simply wrote a ton about international law from a philosophical perspective when compared to all the other theorists in the 20th century that we talk about, that we discuss. He did the most in the field. Now, I invite you to check some of the volumes in the US written almost at the same time about philosophy of international law. You will find volumes in which you can control F, Kelsen, and find
Kelsen.
0 hits. Believe me, 0 hits.
I know. I can
Which
imagine.
which is at least the thing that you can say, this is a bad omission. And it goes through the entirety of this institutional process that we speak highly of at times, reviewer 1, reviewer 2, the editorial board, and everything, and it goes out and it goes to 10, 50, 20 conferences. I mean, it doesn't happen in medicine. It doesn't happen in medicine. I think that because of these small interventions like systematic reviews, which are not huge shifts in the field and so on and so on.
I am not saying... sorry, Fabrizio.
No, so just because to go back, I think this is very much connected with the theory practice connect disconnect. If we have the disconnect, I mean, if we have the disconnect, judges are going to make their decisions, lawyers are going to make their arguments, and we are going to teach our students, and everybody's life will continue. If doctors get the therapy wrong, people remain sick, right? So if academics come to the conclusion that a certain therapy is the best, and it is not, people remain sick. And it is evident that remains an area for further work. So because of the nature of our object of study, it is easier for us in comparison to the doctors to get away with intellectualism.
Mm-hmm. Yeah. I think that there is an issue naturally in regards to our objects of study. There is an issue that it's not so clear how to account for relevance and how to account for what you were saying. Basically, there is no way to verify maybe the truth or falseness of something, falsity, sorry. In the sense of like we can say, okay, A, but then how do you verify A?
Yeah, but that's why, for example, that's why I think that the theoretical analysis of reason-giving practices is really interesting, because at the end of the day, you are trying to redescribe with a different language a certain linguistic practice. So if people generally agree that the redescription fits with the practice, you have done a good job. If people disagree, then you haven't done a good job, right? And one of the problems that we have is that economists in certain law and economics areas insist that they're doing a good job, but lawyers disagree. And then the next step of trying to do a better job is not seriously taken. Which I find very frustrating.
Yeah, and
no, just sorry. One of the areas where you see this most effectively is competition law. Right? Competition law is the competence of fair trade commissions around the world. The word fair appears in all the EU law, competition law tests, right? There have been for 20 plus years attempts of law and economics people to simplify, saying, oh, but these fairness tests, they are not clear. So let's substitute them with efficiency tests. Then what happened that in digital markets, the fairness tests have been clarified and they make economic sense. So all these, there is a lot of linguistic, you say, what people say A, Julieta, but people say hey, A about a linguistic practice. So there needs to be a relationship between your claim and the linguistic practice that you're talking about, because we're not talking about diseases, right? We're not doctors. We are talking about primary linguistic practices with the exception of jury decisions, because those are mostly outcome focused. But to the extent that our focus is clarifying what is going on in the practice, discussing what should be going on in the practice, using importing terms from another language. There are linguistic conditions of success and failure that are quite important, I think.
Oh, just to clarify, I am not saying not going in that direction. I am an empirist. My only the only thing that I was trying to say is that I think that the majority of our fields, or at least legal theory and legal philosophy, they are not dealing with that level of discourses. They are going in another direction. Naturally, we can say this is not the way to go. But if you go in another direction, and if you go, or you are theorizing in a different level, not in a descriptive level, but then in a normative level or something that is going, I think that is the moment in which you cannot find this verification thing that you might, for example, find in, I don't know, medicine. This was my whole point. Mm-hmm. I completely agree with you that what we are doing is trying to have a redefinition, for example, or trying to account for the linguistic practices or the reason-giving practices. We need to do this verification thing. We need to have this adjustment direction of the theory that you were mentioning at the beginning of the episode. I completely agree with you. The thing is that I don't see our fields, or at least the field that we are inside in this moment, going in that direction. And the problem is that if you don't go in that direction, the criteria of success or the conditions of success of certain theories or certain discourses is not clear, and it is maybe defined only by the okay of the participants of the same practice, and then we go in the direction we were mentioning, like the criticism of the criticism of the criticism of Shakespeare.
Yeah, I
don't even think it's agreement, it's relevance.
Okay, sure.
So in a normative, much of the normative private law scholarship exists because people disagree with each other. Mm-hmm. So it's not because people agree with each other, but it's because people disagree with each other. And so this actually creates an incentive to disagree, right? To polarize and this is very important in my work, and I observe it all the time. It is convenient to maintain and reify linguistic distinctions. How many papers at least once per week, I find a paper that uses the distinction between economic and non-economic goals of the internal market of the European Union that doesn't withstand superficial criticism. Still, it is an organizing category that there is, or in US private law theory, there is this distinction that, it's taken from introductory courses of ethics, consequentialist or utilitarian frameworks versus deontological frameworks, right? And what about all the works that manage to derive, rule utilitarianism, right?
That's rather easy. It's like very,
Yeah, sure. As you were saying, we can. It's not the abstract versus concrete. It's not even at the level of the problems. It's even at the level of the theories, right? We can eat banana and we can eat Nutella and we can eat banana with Nutella, for example, right? Concepts can be combined even at the abstract level.
But also this verification is a thing that Jules mentioned at one point, and I was thinking about, you mentioned Milton Friedman at one point, and I noticed all of a sudden a book, The Freedom of Choice by Milton Friedman, that's on my shelf. And Friedman became popular again for various reasons, which we won't delve into. But it's also this thing. So when Friedman rose to prominence basically as a guy who was claiming that you cannot freely change the value of money in order to solve unemployment issues, and that will lead to consequences that are far-reaching. Eventually, in the 70s, it all crashed, led to stagflation. Milton Friedman was right, and he rose to prominence as the greatest economist of all time. And also the quantitative approaches helped him with that, which rose to prominence at the same time. But kind of later on, he was writing about freedom, the ethical foundations. Can these foundations be combined with the economic freedom? And so on and so on. So at one point he was claiming with the rise of markets everywhere around the world, the governments in the world will be democratized. And he elaborated an entire scheme of various freedoms that are interconnected and so on and so on. Eventually he died, not realizing that it didn't happen. So just simply the economic freedom hasn't led to political freedom, kind of breaking down these strong bonds. So, I think that our discussions, if we are being honest, in philosophy of law, eventually pan down like that. Like, either you can map somebody's theory on an existing legal system in 2024, for example, Hart's theory. Either the secondary rules are useful for explaining something in legal practice, or they're not useful for explaining. Either law's integrity is useful for explaining something in legal practice, or it's not useful in explaining. And kind of, I think that we kind of hang on, just like Fabrizio was mentioning, hang on to our beliefs, even if they are in certain ways empirically disproven. Either weakly or even strongly, like in the case of China, for example, and Friedman's supposition that the liberalization will lead to democratization and so on and so on. So, yeah, at least I find my opposition somewhere, my idea somewhere there, that we are overemphasizing the unscrutability of our field from the perspective of systematic reviews, verifiability, and so on and so on.
But Friedman is also a very nice example of the fact that, you can do hardcore Chicago school economic analysis and at the same time use the language of freedom in order to analyze social interactions. What I see a lot of time nowadays is this form of silo thinking where you necessarily assume that it is either efficiency or something else. Fairness, autonomy, equality, it doesn't really matter. And this is connected also with the systematic literature review point, because one of the things that I found and that has really helped a lot, has really helped me a lot structuring my thought on this matter, is this idea that to me there are two main efficiency norms on the table as contestant: total welfare and consumer welfare. Okay, now are they incompatible with equality norms? No, they're not, because the total welfare idea of efficiency is based on a claim of state neutrality, according to which if you are a monopolist and you are exploiting Julieta, who am I, the state, to decide that what is the value for you is less important or more important than value to Julieta? I need to treat you the same. So under this assumption, how can I say that monopoly is bad? I can say that monopoly is bad because the size of the pie for everybody, due to your monopolistic behavior, has been reduced. So while treating you with equal respect, I can still say that monopoly is bad because it reduces total welfare. Now, I can say that monopoly is bad because it reduces consumer welfare. And I appeal to a different equality norm. I make an appeal to a more generalized reciprocity norm, according to which everyone has to exercise effort when they are producers. So just like you owe your best efforts to Julieta when you are producing podcasts, Julieta owes you or owes me and actually owes everybody the same level of effort when she is producing whatever she is producing. So there is a form of equality which is based on a different equality norm, but the two are still intimately connected. But if you review the literature, the overwhelming majority of positions that you will find represented are based on the separation, because separation is convenient. It is easier to reach the 8,000 word threshold if the field is populated by enemies that are all wrong, and you're right.
Well, with these great thoughts, I think we're reaching the threshold of this episode. Because we're approaching, we're 4 minutes shy of finishing the second hour of the podcast.
We could go on.
Julieta is the more responsible one among us two, has been gesturing for a while, and I've been ignoring the gestures, the wrap-up gestures for quite a while. But she's, like the more responsible and the more rational one. So I think that this is a good point, if you agree, Fabrizio, to finish this episode and to promise that we are going to do it at least one more time to continue this. For me, it was a very interesting conversation, and I enjoyed it a lot.
Mm-hmm.
Likewise.
Yeah, hopefully we didn't tire you too much.
I don't know. Did we?
I'm a bit tired, but I think it's a mixture of my son waking up at 4:30 in the morning, me not turning off the air conditioning, the heating in the office.
Also, Julieta and myself haven't seen each other, so she was in Argentina. We haven't seen each other for a month, so we're full of discussion and debate, most probably. We were talking for quite a while.
I am very jet-lagged as well. So.
You're doing fine for somebody who's jet-lagged.
I fake well.
Anyhow, it was a great talk. Thank you so much, Fabrizio. We promise collectively to continue.
Thank you, Julieta.
Yeah, finished finally. I have to try my kid to the karate practice.